It's November 10th, 1950. George Anastaplo waits for a short character interview before he can practice law in Illinois. Instead, one line of questioning derailed his chances and started a 10-year journey. Anastaplo would represent himself, pro se, all the way up to the final boss of our justice system, the Supreme Court. This is how it started.
One of the test questions then being asked was, do you believe that a member of the Communist Party should be permitted to practice law in Illinois? That indeed was the question that was asked of me.
It was obvious how he was supposed to answer.
1950 was a certain period, too.
That's right.
It was beginnings of McCarthy.
It was a
time.
bad period in the Korean War. Things were very bad, and the country was very disturbed for a variety of reasons. People were troubled, and they were worried, and they were looking for things they could do. And one thing was, of course, to root out people who were thought to be dangerous.
The Supreme Court was about to hear arguments in Dennis versus United States about the Communist Party's intent to overthrow the government. Earlier in the year, Senator McCarthy had announced his first list of communists inside the State Department, and Chinese troops had entered the Korean War. And yet, Anastaplo pushed back. Let's return to his radio interview in 1986.
And I indicated that I didn't see why membership in the Communist Party in itself should bar anybody. And then the response of one of the members was, well, but members of the Communist Party believe in revolution. And I said, well, doesn't everybody? And what do you mean, doesn't everybody? Well, let's look at the Declaration of Independence. It says that there are times when revolution, the right to alter, abolish the established government, is proper. In fact, it may even be a duty.
This answer quickly led the board to ask if he was a communist. He said that these questions were improper. More and more questions were asked about political memberships, what newspapers he read, and what he thought about the KKK. It didn't matter to the committee if Anastaplo was actually a communist or not.
At one point of the hearing, after a considerable amount of effort on my part to get the concession from him, the concession was that we have never had any kind of evidence, any information, any suggestion to us that you're a member of the Communist Party, Ku Klux Klan, or any of the other organizations on the Attorney General's list.
He had served in the Army Air Corps.
And volunteer for the Air Corps after having persuaded them that it didn't matter that I had a heart murmur and that I was underweight. I became a navigator. I was rather good as a navigator, as a matter of fact, because it had quite a bit to do with mathematics, and it was no problem.
After the war, Anastaplo attended law school at the University of Chicago, graduated, and passed the bar exam. This interview, usually more of a formality, was also testing if you deferred to the old guard.
If we're talking about people between the ages of 24 and 27, they weren't used to having people like that come in and defy them.
Or question them.
Yeah, or question them. They were really used to a certain kind of subservience.
According to future Chicago Alderman Leon Dupre, the ACLU offered to represent Anastaplo.
He wouldn't permit us to handle the case. We would have introduced evidence about him and his views, demonstrating that he wasn't a communist. He just felt that if that was the way to get admitted, he didn't want to be admitted. He raised the issue very clearly, and now I appreciate his position.
Instead, he continued to represent himself. Faculty and classmates took sides. The law school's new dean, Edward Levi, was notable for his absence. 25 years later, as President Ford's Attorney General, Levi would tell the New York Times,
I thought Anastaplo was wrong. I thought Anastaplo's position was ill-timed. I thought the big problem was the teacher oath cases. I thought to raise the non-communist oath issue with the Character and Fitness Committee was the wrong way to do it, and because of the timing of the thing he would lose and hurt himself, and he did. We were all trying to help him, whether he knows it or not.
After Levi's death in 2000, Anastaplo would praise the Attorney General for, quote, his exemplary service in Washington, but also added,
Levi was understandably concerned about the reputation of the law school, even more than he, no doubt, also was about the welfare of the student whose career was in jeopardy. His effort to induce the headstrong student to be reasonable included a remarkable attempt to intimidate that student's wife as well, an attempt which she never forgot. But, then, those were troubled times, during which quite decent people were moved to do, and to acquiesce in, troubling things.
In 1954, Anastaplo's case reached the Illinois Supreme Court. It didn't go well. The United States Supreme Court then declined to take up his appeal, despite Justices Black and Douglas objecting. At this time, Anastaplo was continuing grad school and picking up odd jobs, including as a taxi driver. One day, as the story goes, he picked up the Chief Justice of Illinois Supreme Court.
Anastaplo reminded him that he had appeared before him in Springfield. "But you're not admitted to the bar?" Daly asked. "That's the idea. I lost the case," Anastaplo replied. "And what's more, you wrote the opinion." The justice exclaimed, "You are not Anastaplo, are you? Why don't you just answer? No one ever thought you were a communist."
Meanwhile, cultural tides were shifting. The Korean War had ended, and after the televised hearings with Army officials, Senator McCarthy was censured by his colleagues.
"You've done enough. Have you no sense of decency, sir, at long last?"
In 1957, the U.S. Supreme Court decided in Schware v. Board and in Konigsberg v. State Bar that members of the Communist Party could be admitted to the bar in those states. They also softened the Smith Act's prohibition on revolutionary speech in Yates v. United States. The time was ripe for now Professor Anastaplo to try again. In 1958, the board asked the same questions, which again led to the Illinois Supreme Court, and this time the United States Supreme Court took up his appeal. Arguments would be heard in December 1960, just over 10 years after the first confrontation. George Anastaplo, the petitioner, went first and told his story. The state's Assistant Attorney General, William C. Wines, would oppose him. Fun fact, Wines was also a pioneer of mock trial television in Chicago. There's an audio record of the whole argument linked in the description. You might be wondering, how well did Anastaplo do representing himself, since that's the point of the podcast? Remember, he had graduated law school and passed the bar, so he isn't going into the Supreme Court totally empty-handed. That said, toward the beginning of Wines' argument, he noted that Anastaplo did not provide a document to the Attorney General's office as expected.
That through a misunderstanding that can't possibly have been due to anything more sinister, devious, or subversive than inexperience, Mr. Anastaplo did not serve the Attorney General with a petition for the writ of certiorari in this case. The first intelligence that the Attorney General, or that I, as chief of his appeals section, had, the petition had been filed, or that there was such a case in this court, was when we received the clerk's telegram saying that the writ had been granted. What happened was that Mr. Anastaplo, I'm sure in the utmost good faith, did serve the Chicago Bar Association or its president or committees, did serve the Supreme Court of Illinois. Neither of those bodies transmitted the petition.
There are also a few points where Anastaplo goes back and forth with the justice about where to find specific quotes and transcripts.
The unanswered questions.
Where is that?
I think it's 3. I'm sorry, sir. All
right, go ahead.
I think it's 234. Yes, 234 on the record.
Anastaplo approaches his argument on several fronts. Who specifically was setting this barrier? Did they have a right to bar someone from practicing law just based on their politics? What about the First Amendment, freedom of association? What about the 14th Amendment's right to privacy? Here, Justice Frankfurter was annoyed, maybe more than annoyed, that Anastaplo said he was unprepared for the communism question, making it a possible due process violation.
Are you saying that you were not aware that your refusal to answer these questions may be determinative of their disposition?
No, I do not want to say that either, sir.
I didn't ask you that question.
I didn't say you were asked. I was asking my question.
Oh, I'm sorry. No. I had a pretty good idea that if I persisted in this position, I might be rejected again. But I also had an idea that there was a possibility I might convert 2 or 3 more.
In short, there is no suggestion, is there, by you that you were taken by surprise?
The first time I was.
I'm talking on
Yes.
the totality of the record. Are you suggesting you were taken by surprise?
No, sir. Not in 1958.
They also argued about how the Declaration of Independence framed a duty to overthrow the government. Would it apply to a Supreme Court decision that you didn't like?
I say if the government itself is tyrannical, if it's an instrument of tyranny, if it's a government which obviously is no longer supporting the Constitution, then it, in any of its branches, executive, legislative, or judicial, no longer deserves support of the people.
But very high-minded people have thought or think that this court has handed down grossly mistaken decisions.
Yes, well, and I have thought so too at times, but I have not thought that any of these have ever justified revolution.
One possible twist, and unfortunately in the modern day I don't know that we can get to the bottom of this one. Wines told the justices that the original question about revolution came up because of something that Anastaplo had published. He denied having published anything before his original hearing.
There was an essay on the right of revolution, of which we make no point of the essay itself as being disqualified.
But you say it was this right
which some member of the committee had read. Why he read it, I do not know.
Where had it been published?
That I don't remember.
Was this published in some periodical?
No, sir. So far as I remember, I had never published anything prior to this occasion.
Well, Mr. Wine suggested that some member of the committee had come upon it somewhere.
I'm sorry, Mr. Wines is simply incorrect.
I see.
I mean, he has a mistaken impression of what happened in that situation.
Wines gave some reasons why being a member of the Communist Party might be acceptable to him if the applicant had a sufficient explanation. These were a bit silly.
If an applicant says, yes, I'm a member of the Communist Party, we can't stop there. We have to say, do you have an explanation? Oh, yes, I can tell you this is a closed hearing. I am an agent for the Federal Bureau of Investigation. They know all about my membership in the Communist Party. Here are my credentials. Yes, I am writing an expose. I can tell you in confidence, a doctor's thesis at such and such a university. Maybe the committee would then think that the man was a patriot, not a potential traitor, and or maybe the Supreme Court would so think and happily admit him.
He also told a story about his own character interview, which lightened the mood.
I do know when I was admitted to the bar, which was in 1932, every applicant was asked if he'd ever been arrested. He wasn't asked anything about communism in 1932, but he was asked if he had ever been arrested for a crime. And I was asked that question, and I had to tell him that through a case of mistaken identity, when I was on my way home and in a hurry, I was arrested for a burglary, and they asked me not a word about communism, but a lot about burglary. But I satisfied.
You were lucky that
And
after they saw you, they were sure that must have been a misidentification.
well, they reached that conclusion. And,
Unfortunately, Anastaplo lost his case 5-4. Justice Hugo Black, who wrote the dissent, asked for that dissent to be read at his funeral in 1971. Colleagues would later attempt to get Anastaplo admitted to the Illinois bar in the mid-60s and the 70s, but he did not cooperate as he was, quote, retired. He had, after all, argued a case at the Supreme Court. In 1968, Anastaplo successfully got the administrators at Rosary College to have the DNC protesters' defense attorney speak on campus. When Edward Levi left University of Chicago to become Ford's attorney general, Anastaplo tried again to find a position at their law school, but he never did. He would teach at Rosary College, now Dominican University, the University of Dallas, the Graham School at University of Chicago, and Loyola University's law school. George Anastaplo passed away in 2014. I'll end with two recordings. First, looking back on his career in 1986.
I couldn't see that the questions they were asking were proper ones, and I wouldn't answer them, and that proved to be the end of my legal career, at least my career as a practicing lawyer. I have a sort of legal career now as a teacher at the law school in Loyola, but it's a different kind of career.
And from his closing argument to the Supreme Court in 1960.
I'm grateful also for Mr. Justice Frankfurter's correction of my notions about the Declaration of Independence. I would insist, still, that any tyrannical action emanating from whatever source is in principle resistible in certain circumstances. That's what the Declaration of Independence holds, and that's what I think this court will surely want others to defend.
If you want to hear more episodes about people representing themselves at the Supreme Court, please like and subscribe. United States Supreme Court rules and practices have changed since these cases. This was a podcast episode, not legal advice.